Elias Vance was a creature of routine, and routine in Silverwood Estates was a finely tuned machine of polished granite and manicured lawns. His ritual was simple. Park the Model Y in his assigned, deed-restricted spot, plug in the wall connector, and let the future quietly recharge itself overnight. The sleek matte black Tesla Charger, his property, installed and inspected 6 months prior with an expensive, hard-fought HOA permit, was the singular indulgence in an otherwise compliant life. He pulled into his spot, 4B, precisely at 7:18 p.m. Fatigue from the 20-mile commute in his role as a software architect was a dull ache behind his eyes. He opened the charge port flap and reached for the connector. That's when he saw it. It wasn't the charger itself that was missing, which would have been theft. It was the cable. The beautiful proprietary cable, which had been neatly looped on its cradle, was now secured to the metal charging head by a thick, brass padlock. The shock was a physical punch to the gut. Instantly dissolving his fatigue into pure electric adrenaline, he gripped the heavy handle, the metal cold and useless. Taped crudely to the charging station's metallic faceplate was a note, printed on expensive cream-colored linen paper. The font was a fussy, overly formal script, to whom it may concern. This charging station has been temporarily reassigned for priority use. As per Silverwood HOA Regulation 3.4b, Emergency Use Protocol for Common Areas, this unit is now designated for the exclusive use of Unit 4A. Any attempt to tamper with or remove the security lock will be prosecuted as a violation of community bylaws and state property damage. Brenda Albright, Unit 4 alias felt. A laugh bubbled up, high and hysterical, but it died in his throat. Brenda Albright, of course. The woman who considered her assigned spot a royal parking mandate, who regularly complained that the smell of his coffee grounds in the shared trash chute was aggressive, and who had once demanded the pool chlorination schedule be adjusted because it interfered with her weekly astrological readings. The entitlement of the note was staggering. He took 2 deep breaths, pulling out his phone. He photographed the lock, the note, and his deed restriction plaque. This was not an emergency. Her car, a gleaming, enormous electric SUV that she treated like a status symbol, was fully charged and parked a few feet away. He walked 20 steps to her unit, 4A. Before his knuckles could connect with the mahogany door, it was yanked open by Brenda Albright herself. She was dressed in an expensive cashmere leisure set, holding a flute of champagne and wearing an expression of smug, preemptive defense. Her eyes, magnified behind stylish reading glasses, were instantly hostile. "Elias," she greeted him. The name a cold chisel. "I assume you've seen my notice." "Notice?" Elias kept his voice steady, a deliberate baritone against the sudden ringing in his ears. "Brenda, that is my property. I paid for the unit. I paid for the installation. I paid for the permit. It is attached to my deeded spot. You can't just lock it." Brenda merely sipped her champagne, her chin raised, exposing the tight skin of her neck. "It's in the common area, dear. The wall is common property, and frankly, your Tesla has been monopolizing it. I require high-speed charging capacity for my vehicle's demands, and you were taking up prime real estate." "I was taking up my real estate," Elias corrected, the anger starting to heat his blood. Regulation 3.4b is for actual emergencies like a power grid failure or a fire, not because you feel entitled to a faster charge than the unit you have in your own separate garage. Brenda waved a dismissive hand. "The HOA legal counsel has already confirmed my interpretation. The wall is common property. The current flowing through that specific junction box is a community resource. And I have proprietary needs that supersede your recreational charging habits." "Recreational?" "It's my only car, and I just drove 20 miles. That is not my problem, Elias. Frankly, the smell of your burning rubber and the constant hum of your vehicle are already a nuisance. Consider this an act of community balance." She stepped back, preparing to shut the door. "Now, I'd advise you to leave the lock alone. The HOA board meeting is next week. If you have a grievance, submit it in triplicate." The door shut with an audible, insulting click. Elias stood there, breathing hard. He was stranded. The nearest public supercharger was 7 miles away, and with his current range, the trip was risky, especially if he had to wait in a queue. More than the inconvenience, the sheer audacious arrogance of the action was a slap across the face of basic civility and property law. He went back to his car, pulled out his laptop, and drafted a concise, furious email to the Silverwood HOA board, copying Brenda for good measure. The response arrived 24 hours later. Not from the board president, Arthur Sterling, but from the community manager, a perpetually exhausted woman named Sarah, who had clearly been given an unenviable task. Subject: urgent property dispute. Unauthorized lock and bylaw violation, Unit 4A4B. Dear Mr. Vance, we understand your frustration. However, after reviewing the materials and consulting with Ms. Albright, the board has determined that the placement of the wall connector, while permitted, is on a structure considered common area vertical surface. The board finds Ms. Albright's temporary designation of the charging unit under the emergency use protocol, while unconventional, to be a matter of good faith interpretation pending a full review. Therefore, the board is requesting that you refrain from tampering with the lock. We will add this item to the agenda for the November 15th meeting. Until then, you are advised to utilize the public charging facilities available at the nearby mall. Failure to comply with this interim ruling will result in a $200 per day fine for non-cooperation. Sincerely, Sarah Peterson, Community Manager, Silverwood Estates. HOA. Elias leaned back in his office chair, staring at the email, the fluorescent light buzzing overhead. A full month. Stranded for a month, paying fines for their failure to enforce his actual property rights, all because Brenda Albright, a woman with 2 other cars, decided his charger was blocking her flow. The fine was the final stinging insult. They weren't just condoning the theft of his utility. They were punishing him for protesting it. This was no longer a spat over a parking spot or a shared wall. This was a naked display of power, an institutional endorsement of entitlement. He realized then that the HOA board wasn't a governing body. It was Brenda Albright's personal committee. Arthur Sterling, the president, was a timid man who folded under the slightest social pressure from the community's wealthiest residents. He knew a formal HOA hearing would be theater, ending only with the formal, written decree that Brenda was right. He spent the next 2 days meticulously researching HOA precedents, property rights, and electric vehicle infrastructure laws. Most of the case law was state level, focusing on anti-discrimination against EV owners. That was the predictable path. File a small claims suit. Waste 6 months, maybe win, and still live next to a vengeful Brenda. But then, he found it. A legal analysis from a prominent firm specializing in infrastructure and constitutional law, discussing the intersection of state-mandated reasonable accommodation for EV infrastructure and the Federal Communications Commission's, FCC, right-to-use regulations, which had been interpreted in some jurisdictions to protect access to utility infrastructure, particularly when a property owner had secured all necessary permits. It was a long shot, a massive escalation, but the loophole was breathtakingly clear. By interfering with his duly permitted utility access and subsequently being backed by a body acting as a governmental proxy, the HOA, they had potentially crossed into a federal question regarding his civil right to use and operate an FCC-regulated energy technology. Elias stared at the firm's contact page. Gibson, Thorne and Associates. Constitutional and regulatory litigation. He didn't want to fight a neighbor. He wanted to end the war. He called the number, his hand shaking slightly. The receptionist asked what the nature of the suit was. "It's a property dispute over a charger," Elias said, swallowing hard. He heard a brief, polite chuckle on the other end. "Sir, we specialize in cases that—" Elias cut her off, his voice suddenly hard and clear. "The Silverwood HOA is unlawfully impeding my access to duly permitted registered utility infrastructure. They have officially sanctioned the lock and threatened fines. The claim is property rights violation and possible interference with interstate commerce regulations, potentially infringing on federal statutes regarding energy and communication infrastructure access." The laughter stopped. There was a pause. "Please hold." "Mr. Vance, I'll transfer you to senior partner Thorne's direct line. The powerful beat of that evening was the realization that he was about to swap the petty politics of Silverwood Estates for the brutal, unforgiving mechanism of the U.S. legal system. He wasn't suing Brenda Albright for 50 cents of electricity. He was suing the HOA on a federal premise, threatening to tear apart their entire regulatory framework and set a precedent they couldn't possibly afford. He was going to bring a cannon to a knife fight. The war had begun. The office of Gibson, Thorne & Associates was a study in intimidating minimalism. Polished concrete floors, walls of seamless glass and abstract art that looked less like decoration and more like a conceptual rendering of a six-figure settlement. Elias Vance sat across a massive dark wood table from Mr. Julian Thorne, a man whose expensive suit seemed tailored less to his body and more to his air of unflappable authority. Thorne didn't waste time on pleasantries. His attention was focused entirely on Elias's meticulously prepared binder of documents, the HOA permit, the deed restrictions, Brenda Albright's handwritten note, and the HOA's official response demanding fines. Most people who come in here thinking they have a federal case have a parking ticket and a grievance, Thorne said, his voice a low, gravelly rumble. He didn't look up, instead tapping a silver pen against the email from Sarah Peterson. You, Mr. Vance, have a community acting as a governmental proxy, deliberately restricting access to utility infrastructure you legally installed, citing a vague, non-existent emergency protocol, and then threatening financial penalty for non-compliance with the restriction they approved. That's not a parking ticket. That's institutional hubris. Elias leaned forward. So the federal angle holds? It's a strong gambit, Thorne confirmed, finally meeting his gaze. His eyes were sharp, evaluating. We won't be arguing property lines, Mr. Vance. We will be arguing that by selectively enforcing an arbitrary rule against a permitted utility installation, the Silverwood Estates HOA has infringed upon your protected right to use essential services and has acted ultra-vires beyond their delegated powers in a manner that interferes with interstate commerce and federally regulated infrastructure. The moment they signed that fine notice, they gave us the jurisdiction. We're not suing Brenda. We're suing the entire regulatory framework of the HOA, and we want an injunction to force them to restore access and cease all enforcement actions immediately. What is the cost? Elias asked, feeling a cold knot of dread mingle with hope. Thorne named a number for the initial retainer that made Elias blanch. It was more than the Tesla itself was worth. This is a statement, Mr. Vance, not a negotiation. We are not interested in $200 fines. We are interested in precedent. If you want this solved cheaply, call a small claims lawyer. If you want to burn their system to the ground, we proceed. Elias thought of the padlock, the entitled smirk on Brenda Albright's face, and the cold institutional dismissal from the HOA manager. I proceed, he said, his voice firm. At 4 p.m. the following afternoon, Sarah Peterson, the overworked and underpaid community manager, was stuffing meeting folders when the office fax machine, an obsolete relic she prayed would die, suddenly whirred to life with a demanding, aggressive energy. The toner-stained pages that spat out were thick, heavy, and smelled of money. The header of the document was simple, black, and terrifying. Gibson, Thorne & Associates. Sarah's eyes scanned the text. Her hands began to shake almost immediately. Motion for immediate restraining order. U.S. District Court for the Central District of violation of 47 U.S.C. Paragraph 201. Citation of FCC utility regulations. Anticipated complaint for damages and injunctive relief. She dropped the entire stack and scrambled for the phone, dialing Arthur Sterling, the HOA president. He picked up on the third ring, sounding distracted. Arthur, it's Sarah. Stop everything. We just got served. We just received this. Received what, Sarah? Is it the landscaping quote? Because I think we can go with the cheaper. It's a federal court filing, Arthur, from Elias Vance. He's not suing us over the fine. He's suing the entire board in district court. It mentions the FCC and interstate commerce. What is he talking about? A dead silence stretched across the line, thicker than any tension Sarah had ever felt in a decade of managing community complaints. "Federal? Court?" Arthur finally whispered, his voice cracking. "Sarah, that's not possible. That's just a Tesla charger. Our attorney, Mr. Jenkins, handles our cases. Call Mr. Jenkins immediately. Tell him to stop it." Mr. Jenkins, the HOA's local counsel, a man whose specialty was drafting cease and desist letters for loud parties and unpaid pool fees, took 40 minutes to return Sarah's panicked call. When he did, his voice was thin, nervous, and utterly stripped of its usual bravado. "Sarah, I've reviewed the service copy," Jenkins said, skipping the usual formalities. "This firm, Gibson Thorne, they are serious. They handle cases for major utilities. They don't touch HOA disputes. This is a targeted strike. They didn't even file in small claims or state court. They went straight for federal jurisdiction. They've successfully framed this as a regulatory utility issue, which destroys our liability shield." "Liability shield?" Sarah choked out. "Yes. We are now exposed to a federal lawsuit, which means federal discovery, federal rules of evidence, and potentially massive federal sanctions and fees if we lose. Our current HOA insurance policy. Sarah, I don't think we are covered for this level of litigation. They are threatening to depose the entire board and challenge the fundamental nature of our governing documents. This isn't a fine war anymore. This is a solvency crisis for Silverwood Estates." Arthur Sterling, who had joined the conference call trembling, finally spoke up, his breath hitching. "Can't we just give him the charger back? Tell Brenda to unlock it and forget the fine?" "Too late," Jenkins sighed. "They have already filed the TRO motion, demanding immediate injunctive relief. If we simply unlock the charger now, they'll argue we admitted guilt, but they'll still proceed with the claim for damages and attorney fees, which, knowing Thorne, will be astronomical. We are formally instructed to take no further action without counsel. Do not speak to Mr. Vance. Do not speak to Brenda Albright. Do not, under any circumstances, unlock that charger or rescind that fine notice until I get confirmation from a litigation specialist." Elias had been living off supercharger stops and public level 2 stations for 3 days. The process was inconvenient and expensive, but the thought that Brenda's petulant action had triggered a legal apocalypse was a delicious, fueling antidote to his frustration. He saw her later that evening. She was outside her unit, supervising a young man who was struggling to load several expensive shopping bags into her car. She spotted Elias walking from his freshly parked dark blue Model Y and marched straight toward him, her cashmere robe swirling dramatically around her ankles. "Elias!" she hissed, stopping 10 feet away. The champagne confidence from days before was replaced by a taut, white-knuckled rage. "What is this nonsense?" "I got a call from Arthur Sterling. The man was weeping. He said you filed something with a court downtown. Why would you do something so disproportionate?" Elias remained calm, remembering Thorne's instruction. "Speak only facts. Show no emotion. Ms. Albright, as I informed you, the charging unit is my private permitted utility infrastructure. Your unilateral action in locking it constituted unlawful interference. The board subsequently endorsed this interference and threatened me with fines. It was temporary. It's for the community." She spat, gesturing wildly. "The board's decision to endorse your interpretation of Regulation 3.4b now renders them liable for all damages, including but not limited to the legal costs associated with establishing the precedents of federal utility and commerce law over community covenants. I am now represented by Gibson, Thorne, and Associates." The name landed like a physical blow. Her eyes narrowed, her face momentarily freezing in a mask of realization. She recognized the weight of that name. That's completely insane. You spent thousands of dollars just to spite me over a plug. I am exercising my right to uninterrupted utility access without illegal institutional interference," Elias stated simply. "I advise you to consult the documents your HOA has received and speak with your own counsel. Do not speak to me again regarding this matter." He walked past her, the wind of his passing seeming to steal the air from her lungs. She watched him go, her mouth working silently, a woman realizing for the first time that her minor tyranny had triggered a disaster beyond her social reach. The final, Powerful beat came late that night via email. Elias was scrolling through news articles on his phone, half expecting the first fine notice to arrive, when an email with the subject line, "Notice of Temporary Stay of Enforcement," appeared from Sarah Peterson. The text was short, clipped, and devoid of the usual passive-aggressive formality, pursuant to the pending motion for injunctive relief filed in the U.S. District Court. The Silverwood Estates HOA Board hereby issues a temporary, immediate stay on all enforcement actions, fines, and disciplinary proceedings related to Unit 4B's use of the Tesla charging station until further notice from specialized legal counsel. No further communication regarding this matter is authorized. Elias felt a slow, triumphant smile spread across his face. The padlock was still there, cruel and useless, securing the charging cable in its socket. Brenda still had her claim. But the HOA's fangs, their ability to fine, threaten, or enforce anything, had been chemically neutralized. They were paralyzed, frozen in fear of the federal court. He pulled up the photos of the padlock on his phone, magnified the crude linen note taped beneath it, and then reread the stay of enforcement email. The HOA had lost the power to govern, and Brenda's trophy, the brass lock, was now a monument to their complete-eyed dar. The padlock remained, a brass elephant in the assigned parking space of Unit 4B. It was a tangible, immutable symbol of the lawsuit's complete success in freezing the HOA's functions. Elias still had to drive 20 minutes to a supercharger every few days, but the inconvenience was now a necessary inconvenience, a small price to pay for the strategic victory. Every time he looked at the lock, crude, bulky, and utterly ineffectual beneath the terrifying letterhead of the court documents, he felt a surge of cold, focused determination. The emergency board meeting was held in the HOA clubhouse's boardroom, typically reserved for discussion of pool maintenance and shrubbery budgets. Tonight, the air was thick with the scent of cheap coffee and expensive panic. Seated around the mahogany table were the 5 directors, flanked by 2 people who had replaced their local counsel, Mr. Jenkins, who had wisely offered his immediate resignation, the new, terrifying litigation specialist, Ms. Diane Cross, and her associate, Ms. Cross, did not waste time. She was sharp, dressed in a charcoal suit that looked like armor, and spoke with the chilling clarity of actuarial science. "Let's be unequivocal," Cross began, sliding a copy of the TRO motion across the table. "Mr. Vance's lawyers, Gibson, Thorne & Associates, are not interested in the merits of the padlock. They are interested in making an example of you. Their strategy is a classic jurisdictional end run. Use a state-level dispute, which your prior counsel grossly mishandled by issuing that fine, and elevate it to a federal regulatory question. Your insurance, which covers typical premises liability and general HOA disputes, will not cover the costs of a constitutional law defense. We are essentially operating without a net." Arthur Sterling, the president, looked pale and small in his oversized chair. "But it's just a dispute over a charger. Can't we just claim good faith?" Brenda claimed it was an emergency. Cross fixed Sterling with a gaze that could wither granite. "Your good faith evaporated the moment you ratified the fine. That was an act of enforcement, not mediation. Furthermore, the emergency use protocol cited by Ms. Albright, Regulation 3.4b, explicitly applies to emergency utility failure impacting all units, such as a water main break. It does not allow for the selective appropriation of a duly permitted utility outlet based on subjective needs. In short, Ms. Albright's action was baseless, and your subsequent endorsement of it was legally negligent." "What's our exposure?" asked Mr. Henderson, the treasurer, his voice tight. "The request for injunctive relief will likely be granted, forcing you to remove the obstruction. The real danger is the request for damages and legal fees, which, for a firm of this caliber, will likely exceed $300,000. Potentially more if they succeed in getting a declaratory judgment that your bylaws are ultra vires on a federal level. That money must come from somewhere. That somewhere, gentlemen, is the community's reserve fund. If we lose, Silverwood Estates will be bankrupt." A collective gasp went around the table. The reserve fund was their safety net, their hedge against major infrastructure failure. "We need to issue a statement," Cross dictated, tapping the pen again. We immediately rescind the fine against Mr. Vance. We formally disavow the application of Regulation 3.4b in this matter and state publicly that Ms. Albright's action was a personal, unauthorized act of obstruction. We throw Brenda Albright completely under the bus. We can't do that. She's a major donor to the community center, cried Mrs. Delacroix, the social committee chair. You have two choices, Cross responded without emotion. Disavow Ms. Albright and attempt to narrow the scope of the case back to a personal dispute, though Thorne will fight that, or stand by her and risk losing the entirety of the community's financial security. The choice is quite clear. Arthur Sterling slumped in his chair, running a hand over his bald head. Draft the letter, Ms. Cross, immediately. Brenda Albright felt the ground shift beneath her feet, not when the HOA stopped communicating, but when the community manager, Sarah, sent her a clipped, formal email attaching a copy of the HOA's new legal statement. The language was sterile, but the meaning was a betrayal. The board wishes to make clear that the lock placed on Unit 4B's charger was an unauthorized, unilateral action taken solely by the occupant of Unit 4A. Brenda was not used to being isolated. She was a pillar of Silverwood society, host of the annual summer gala, the one who dictated the shade of gray paint for the new common fences. Unilateral? She shrieked to her husband, Robert, who was reading the Wall Street Journal with an expression of stoic fear. They said I was unauthorized! Arthur Sterling told me the board supported the spirit of the action. They have 300,000 reasons not to support you anymore, Brenda, Robert said, not lowering the paper. You brought a federal lawsuit to our doorstep over a $1,200 charger. You have to unlock it, dear. Right now. Before they start charging us for their outside counsel, I will not concede to that miserable, humorless Elias Vance, Brenda declared, pacing her pristine Persian rug. If I unlock it, he wins. I need to show the community he's the real threat. He's the one destroying our home values by bankrupting the HOA. I need to mobilize the neighbors. The next day, she began. She knocked on doors, clutching a printed copy of the federal filing, highlighting the astronomical figure of the requested damages. She framed the lawsuit not as an act of personal vengeance against her, but as an assault on the HOA's governing authority. This man, she told the Greers, who lived across the street, wants to dismantle our community's protections. If he wins, we can never enforce a rule again. He's using this charger as an excuse to bankrupt our safety fund. To her shock, the response was tepid, even hostile. Brenda, Mrs. Greer said, adjusting her glasses, you locked his charger after he got the permit. It was unnecessary. We all know how essential those vehicles are. My son-in-law drives one. It was a petty thing to do, and now the whole neighborhood is paying for your pettiness. Even worse was the response from the young tech couple in Unit 5C. You're talking about a utility. Ms. Albright, we need power. If the HOA can just revoke access to permitted utilities on a whim, how is anyone supposed to function? Frankly, Mr. Vance is just protecting his property rights. You were completely out of line. The support she expected, the solidarity of the entitled, never materialized. Her social capital was worthless against the cold, hard logic of property rights and the universally understood reality of her overreach. The neighbors didn't care about the lawsuit's scope. They only cared that she started it, and now they were going to pay for it. Meanwhile, Elias received his first communication from the U.S. District Court, a formal notice regarding the temporary restraining order. It was not a final ruling, but a preliminary order from the presiding judge, Eleanor V. Ramirez. The court had scheduled a formal evidentiary hearing to consider the merits of the injunction for the following week. However, the ruling contained a short, decisive paragraph. Pending the evidentiary hearing on the immediate injunctive relief sought by the plaintiff, Vance, and acknowledging that the property in dispute is an installed and permitted utility access point, the court finds that continued physical obstruction of said utility constitutes an ongoing, irreparable harm to the plaintiff's property use. Therefore, the defendant, Silverwood Estates HOA, is hereby mandated to facilitate the immediate removal of the non-compliant obstruction, the brass padlock, by 5 p.m. today, ensuring the plaintiff may return to normal use of his permitted utility infrastructure, pending the outcome of the subsequent hearing. Elias stared at the timestamp, 3:30 p.m. The judge hadn't just ordered the HOA to take action. She had given them a deadline of 90 minutes. The legal system, which had moved with the slowness of a glacier, had suddenly accelerated to the speed of a bullet. At 4:45 p.m., Elias drove into his spot. He parked and stepped out. Waiting nervously by the charger was Arthur Sterling, the HOA president, clutching a pair of heavy-duty bolt cutters. Beside him stood Sarah Peterson, the community manager, filming the entire interaction on her phone, presumably for legal documentation. Arthur Sterling looked defeated, his eyes red-rimmed. He wouldn't look Elias in the eye. "Mr. Vance," Sterling stammered, holding up the court order with a trembling hand. "The judge mandated this. We have to comply with the order for removal. I apologize that we allowed Ms. Albright's unilateral action to get this far." "I accept your apology, Mr. Sterling," Elias said, stepping aside to give him clear access to the charger. He watched as Sterling approached the sleek black unit, the small, absurd brass padlock mocking the HOA's defeat. Just as Arthur Sterling raised the bolt cutters, the terrifying jaws of the machine of justice poised to sever the symbol of Brenda's entitlement. Brenda, Albright herself, burst out of her unit screaming, "No! You coward! It's my emergency protocol! You can't let him win!" She launched herself forward, trying to physically obstruct Sterling. Arthur Sterling, weak, intimidated, and utterly terrified of the consequences, simply turned his back on Brenda, ignored her hysterics completely, and brought the cutters down. The sound of the bolt cutters shearing through the brass lock was like a gunshot, echoing across the silent, manicured lawns of Silverwood Estates, a deafening declaration that the federal court had physically intervened in their petty governance. The charging station, once again functional, was a beacon of cold, technological justice, humming softly as it fed power back into the Model Y. But the silence surrounding it was brittle. The air in Silverwood Estates, usually thick with the quiet contentment of the wealthy, was now electric with resentment. The neighbors avoided Elias's eye, unable to reconcile their fear of the federal lawsuit with their lingering social loyalty to Brenda Albright. Brenda, for her part, had retreated into a poisonous silence. She hadn't made eye contact with Elias since the sound of the bolt cutters echoed across the courtyard. Her enormous electric SUV, which she previously moved only to showcase, now sat idle, parked precisely on the very edge of her assigned space, Unit 4A, making ingress into Elias's Unit 4B unnecessarily tight. It was a minor, daily aggression, a physical manifestation of her unyielding spite. Elias had resumed his routine, but it was fraught with paranoia. He meticulously checked the charging cable every night, half expecting to find a fresh layer of superglue or some new, insidious obstruction. He took pictures of the charging station before and after every session. The petty war had become psychological. 3 days after the TRO mandate, Elias sat across from Julian Thorne, his attorney, in the glass-walled office. The mood was one of cautious victory. "The TRO held, Mr. Vance," Thorne summarized, leaning back, the silver pen tracing the edge of a deposition schedule. "Judge Ramirez accepted the argument that the HOA's ratification of the lock, coupled with the threat of fines, created an irreparable harm to your permitted utility use, giving us the jurisdictional hook we needed. They are currently reeling. We have Arthur Sterling and Sarah Peterson scheduled for deposition next week." "What about Brenda Albright?" Elias asked. "Ms. Albright is the critical factor now," Thorne said, his voice hardening. "We have formally requested her deposition, as she is the principal agent of the initial obstruction and the one who invoked the non-existent emergency protocol. The HOA is desperate to keep her off the stand, arguing her actions were purely personal and unauthorized, which, as you know, is their only way to narrow our case and preserve their reserve fund. But they signed that fine notice," Elias countered. "They endorsed her claim." "Exactly. And that is what we will pound into them. We need to prove this wasn't just mismanagement on the part of the board, but willful negligence that led to a deprivation of your property rights. If we can prove they acted with malice or a reckless disregard for the documents, the damages increase exponentially. This case is about forcing a settlement that remakes their bylaws and covers all our fees, ensuring no resident ever faces this tyranny again." Thorne paused, then slid a thick packet of documents across the table. However, in discovery, something interesting came up regarding Ms. Albright's alleged emergency. We forced the release of her communications with the HOA regarding utility usage just prior to her locking your unit. We initially thought she was simply entitled. Now I think she's desperate. Elias opened the file. It was a redacted, heavily marked copy of the Albrights' utility statements and a series of frantic, poorly worded emails Brenda had sent to the community manager weeks earlier. The Albright family energy usage is astronomical, Thorne explained, far exceeding a typical household, even with their SUV. Look at the last page. That's an internal HOA note flagging the Albrights' account for near-term suspension of optional common area amenities due to an apparent failure to settle recent high-load energy overages. Elias read the note. It wasn't about the HOA fees. It was about a specialized utility bill for a power-intensive home feature, a sprawling, climate-controlled wine cellar, and a separate, large electric vehicle charger. In their private garage, that was linked to the common area's high-tension infrastructure before being metered separately. Her private charging unit failed due to an electrical fault, Thorne deduced. Or more likely, her husband Robert is having a serious hidden financial collapse, a liquidation event perhaps, and they are scrambling to save every dollar. She wasn't locking your charger out of pure greed. Mr. Vance, she was trying to use your permitted, metered hookup to illegally charge her massive SUV for free, dumping the load back onto the common area grid to avoid paying a huge, separate commercial rate she couldn't afford. Her emergency was a fiscal one, hidden under a cloak of entitlement. A cold clarity washed over Elias. This wasn't just a snob fighting over prestige. This was a woman facing financial ruin, willing to commit petty larceny against a neighbor and risk a federal lawsuit just to power her status symbol. It made her unpredictable and dangerous. She's exposed, Elias said. If we present this at the injunction hearing, she's finished. Precisely, Thorne confirmed. Which means she knows her deposition is coming, and she knows we have the documents that expose her family's fragility. A cornered animal is the most dangerous kind, Mr. Vance. Elias left the firm feeling both vindicated and acutely vulnerable. He knew Brenda wouldn't simply accept defeat. The loss of her social standing, the public humiliation, and the threat of financial exposure were now concentrated into a volatile cocktail of rage. That evening, the air was still and thick with the scent of pine and impending rain. Elias pulled into 4B, meticulously checking the area. Brenda's SUV was gone. A relief. He backed into his spot, reached for the charging cable, and felt an immediate sense of wrongness. The latching mechanism felt loose. He plugged the charger into his car, expecting the reassuring, solid thunk. Instead, there was a faint, unsettling click, followed by a high-pitched, oscillating whine from the wall unit. He glanced at his Tesla screen. Instead of the steady green charging indicator, a terrifying red banner flashed, "Critical electrical fault. Charging halted. Consult service immediately." Elias immediately yanked the cable free. The charging port on his car looked unharmed. He turned his attention to the wall connector itself. The unit's metallic shroud was slightly ajar at the bottom seam, and the small, brightly colored QC sticker, a quality assurance seal that indicated the connection to the breaker box was tamper-proof, was cleanly sliced through with a razor blade. Someone hadn't just unplugged him. Someone had used a tool to compromise the internal wiring junction of a high-voltage electrical unit. The high-pitched whine continued. Elias pulled out his phone, activating the flashlight and aiming it into the slight gap in the housing. He saw a glint of metal and a thin, exposed wire, seemingly stripped and repositioned near another terminal. His heart hammered in his chest. This was beyond petty spite. Tampering with a 240-volt dedicated line was not just vandalism. It was a criminal act of sabotage that could cause a massive surge, short out his expensive car's internal battery management system, or, more horrifyingly, ignite a major electrical fire in the common wall separating his unit from the rest of the building. He stumbled backward, the fear overwhelming the anger. He looked up, his eyes scanning the windows of Unit 4A, Brenda Albright was standing in the shadows behind her pristine white curtains. She wasn't yelling or gesticulating. She was just watching, the light from her living room casting her silhouette as a still, patient predator. Elias realized that the initial padlock was a triviality. He hadn't just started a lawsuit. He had activated a monster. He had the legal victory, but he had just narrowly avoided a deliberate, malicious catastrophe that threatened his life and his home. The fight had left the courtroom and returned to the parking lot, but this time, the stakes were lethal. He needed to get the police and the fire marshal involved before the evidentiary hearing, because this was no longer a civil dispute, but an attempted felony. Elias did not hesitate. He retreated 20 feet from the humming, tampered charging station and called 911, reporting attempted felony vandalism and the potential for a catastrophic electrical fire in a multi-unit dwelling. He then immediately called Julian Thorne, his lawyer. "Mr. Vance, what is it?" Thorne's voice, though guarded, held a note of annoyance at the late-hour intrusion. "She tampered with the wiring," Elias reported, his voice flat with residual shock. "Brenda." She sliced the QC seal and altered the internal junction. The car aborted charging with a critical electrical fault. It was an intentional act of sabotage, threatening to short out my car or, worse, start a fire in the shared wall. I saw her watching me from her window. The lawyer's annoyance vanished, replaced by an electrifying silence. "Do not touch anything, Mr. Vance. Do not speak to anyone. Lock your phone and wait for law enforcement. We are no longer discussing civil damages. We are now discussing an attempted criminal act. I am calling the lead investigator for the U.S. Attorney's Office right now, and I will be at the district court before dawn with an emergency motion for a restraining order and sanctions." Within the hour, 2 squad cars, a uniformed police officer, and a fire marshal's truck arrived at Silverwood Estates. Their presence an immediate, humiliating spectacle for the high-end community. The police took Elias's statement, documenting the precise angle from which he had seen Brenda watching. The fire marshal, an experienced man named Captain Reyes, meticulously photographed the tampered charging unit, using a high-resolution camera to capture the cleanly sliced sticker and the deliberately stripped wire leading to a nearby terminal. This was not an accident. "Sir," Reyes confirmed gravely, sealing the unit with an official evidence tag. "The unit has a surge protection system that likely saved your vehicle's battery, but the intent here was to create an overload or a short circuit. If that had sparked at 240 volts in this enclosed space, especially near the internal structure, the fire risk was extreme. We are filing this as a criminal complaint for felony vandalism and attempted arson." As the fire crew packed up, a local patrol car approached Unit 4A. The officer, acting on the criminal complaint, knocked. The subsequent muffled shrieking from inside Unit 4A was the final sound Elias heard before he drove away to spend the night at a hotel, his Model Y safely parked far away. The neighborhood was awake, watching the flashing blue lights, their fear of a lawsuit now replaced by the terror of a criminal investigation in their midst. The next day, the small, sterile hearing room in the U.S. District Court was packed. It wasn't just Judge Ramirez and the legal teams. The entire Silverwood Estates HOA board, looking terrified and haggard, occupied the front bench. They were desperate to settle, their legal specialist, Diane Cross, having informed them that their collective exposure, civil liability compounded by potential criminal complicity, was absolute. Julian Thorne stood before the judge, his presence radiating controlled menace. He was not there to argue the merits of the padlock. That was settled. He was there to execute the full scope of his client's federal victory. Cross, on behalf of the HOA, immediately tried to narrow the scope. "Your Honor, we move to settle. We propose full payment of Mr. Vance's initial legal fees, a formal retraction of the fine, and an amendment to the bylaws to prevent any future arbitrary enforcement concerning utility hookups." Thorne did not even let the judge respond. He held up a copy of the fire marshal's report, stamping it down on the podium. "Your Honor, we vehemently oppose the defendant's attempt to minimize this case now as a mere dispute over fees. Over the past 24 hours, the plaintiff was the victim of an alleged felony, an act of electrical sabotage confirmed by the fire marshal's office, threatening life and property, perpetrated by the very individual whose actions the HOA board ratified and defended with institutional power. A murmur swept through the room. Judge Ramirez, known for her sharp control, looked directly at Thorne. "Counselor, are you implying that the criminal act is related to the civil dispute?" "Your Honor, the individual who performed this malicious act, Ms. Brenda Albright, was the same individual who initiated the original obstruction and whose financial distress the HOA attempted to conceal. This is not a dispute over a parking space. This is an institutional failure to protect a citizen's right to safely use a permitted utility, resulting in a direct threat to that citizen's safety. The defendant's institutional negligence enabled this escalation." Thorne then laid out the final terms of the settlement, demanding 3 components: monetary damages, full reimbursement for all of Elias's legal fees, plus $250,000 in punitive damages, to be paid immediately from the HOA's reserve fund, structural reform, a mandated, immediate restructuring of the HOA's governing documents requiring a third party, federally certified utility and property rights consultant to draft new bylaws that explicitly align with state and federal utility access laws, overriding all existing covenants that contradict them. This effectively stripped the board of their arbitrary power over permitted property usage. Governance sanctions. The entire current HOA board was required to sign a resignation letter, effective immediately upon the acceptance of the settlement, and be barred from serving on the board for 10 years. Cross looked at her clients, the terrified board members, then back at the judge. She knew the consequences of fighting the charges, especially with the criminal investigation underway, would lead to insolvency and the dissolution of the entire community association. The defendant accepts the settlement. "Your Honor," Cross stated, her voice leaden with defeat. Judge Ramirez brought down her gavel. "So ordered. The Silverwood Estates Homeowners Association is hereby commanded to execute the terms of the structural and monetary settlement immediately." Elias walked out of the courtroom 2 hours later. The papers signed. He had won more than money. He had won precedent, forcing a catastrophic institutional change that ensured no resident would ever face the same arbitrary tyranny. The final devastating beat came later that afternoon. Elias was packing up his sparse belongings from the hotel when Thorne called him, the lawyer sounding oddly satisfied. "Mr. Vance, I have 2 updates for you. 1, the funds transfer is complete. You are paid in full. 2, and more importantly, the police, based on the evidence collected at the charging station and the testimony, served Ms. Albright with a restraining order and an arrest warrant this morning. She was taken into custody for felony vandalism and obstruction of justice." Thorne paused, letting the implication sink in. Her husband, Robert, finally confessed in a panic. "Their financial situation is worse than we thought. He needed access to any free electricity to power a critical server farm hidden in their wine cellar, the true reason for their astronomical power bill. And Brenda was attempting to tap your unit to hide the load. They weren't just running a high-consumption household. They were running a small, illegal, unregistered commercial operation out of their home." Elias hung up the phone and drove back to Silverwood Estates. The police tape was gone, but the atmosphere was funereal. As he pulled into his spot, he saw the final chilling image. Unit 4A. The windows were dark. The massive electric SUV was gone, towed as part of the evidence collection. A small, official-looking notice was taped to Brenda's door. Notice of foreclosure and immediate lion. Brenda Albright, who had sought to enforce a fraudulent, self-serving emergency to steal a few $100s in electricity, had lost her status, her reputation, her home, her freedom, and the entire financial solvency of the community she sought to rule, all because she underestimated a neighbor who was willing to elevate a dispute over a single electric plug to the level of federal court. The padlock was gone, but the heavy, expensive door of justice had swung shut, trapping her and her ambition inside a ruin of their own making.